morning, everyone. Good morning. It's 10 a.m. and you are brave to be here. Good morning. Some known faces. Great. Hello. Hello. Please join us. The seats in the front are more comfortable. This year we have a special feature that we call smell that you don't have in the front. Just saying. Thank you for joining me this morning. I'm always on the lookout for stuff to talk about that has a legal background that could interest people at Revision or demo parties in general. So if, in case you run into a question that you don't see answered in this talk, there are tons and tons of questions that you could pose and that we can discuss. Lawyers discuss stuff. Then please let me know if, of course, you're always welcome to pose a question. I roughly envisage this talk to go for 30 minutes, plus maybe 10, 15 for questions. Does either of you want to participate in the 5K run? Okay. Do you have your clothes with you? Because in case the questions run for long enough, you will be the extra feature in this talk. Changing clothes. Yes? No? Okay. Legal questions. In case anything is missing that you see not covered at all, please approach me because I might be covering those in the next year. You never know. And for the visuals, because some of you have probably seen the banner, some. Big thanks go out to Christoph Mütze, also probably better known to you as Gizmo of Farbrausch. He is so awesome for doing this. And he doesn't quite know it yet, but I converted the source file that he also sent to me to this. So if it doesn't look all that great, it's because of me, not because of him. Okay, let's start. 9 legal questions you wish you had known when you started coding for money, la-da-dee, la-da-da. It's going to be actually a really easy, like backward, forward, backward, forward. I'll pose a question or a legal issue that I see arise in various affairs that my clients approach me with, and thoughts to either circumvent something or to avoid something entirely or to renegotiate, get rid of certain stuff. Just in case that is somehow necessary. One of the things that I always, and some of the stuff that I will talk about will be German law specific or at least EU law specific. I'm not quoting any laws here because it's not going to be much worth. If you need to know a certain law in Germany, it's fine. I can look it up for you or even tell you right away. But many of the principles that I talk about this morning are so basic that you could probably even do pretty much the exact same stuff in the US. Asia is always a little different, but not as different as you would think. So in case you're trying to do business with China, for example, that could be something that's covered here as well, even though I don't say so specifically. The first legal thing I called, must you always have the last word? You might know that from your private relationships, but it's pretty much the same in legal relationships too. What I'm trying to say is, in the very beginning, before you actually start to work for a client, you need to agree on something. It's called a contract or agreement, obviously. And somehow we need to come to an agreement. One of you, it could be the client, it could be you, offers something. And of course, depending, I'm pointing this at people who are either selling their software creation skills, coding, whatever, freelance maybe, or are looking at doing that. If you are employed and you don't care about how to market stuff, but you have to look at contracts anyway, this might be interesting to you too. But I'm trying to help you market and sell your coding skills as well as possible with this talk. So coming to an agreement, how do you do it? You could say, I offer my skills for an hourly rate of and the client could say, yes, please. That would be a very, very brief agreement, I give you that, but it would be an agreement of some sort. You would always have to interpret, so whenever you don't have it written on paper, which is not all the time really all that necessary, but if you do, you better make sure to cover all the what-ifs. In many cases, when coders approach me, what I do is posing all the what-if questions. What if the client really expects you to do What if the client actually expects to have the project lead and you only support? What if the client actually expects you to deliver to him a ready-made executable and you have a disagreement? So this first thing is all about disagreement. I call it the love child of offer and acceptance, because a contract consists of offer and acceptance, really. Someone offers something, the client could say, please offer me, I would like this and that of you. Is that okay for you? And you go, okay. Then you have an agreement too. One of the things that you need to take much care about is the advanced setup. The lamp setting. Muting. Oh, muting. Oh, it sounds much nicer. Oh, thank you. Okay, when you accept an offer, oh, that's actually much better. When you accept an offer, but you pose a new condition, that is really not accepting. That is a new offer. You might know that if you send out a quote or an offer, and the client says, and you say an hourly rate of something, and let's say 70 euros. And the client comes back and says, okay, I'm okay, but let's make it 60. That is really not an agreement. It's not accepting. It's sort of making a new offer. And that looks really basic, but that is so fundamental, because sometimes it gets really, really wishy-washy, especially when you offer something to bigger clients with different people that see your quote or your offer. Sometimes you get something back and you go, is that a yes or is that a no? Because what I say is, I'm sorry. A yes but is really rather a no unless. So what you always want to look for is a yes. Like, is that what I offered you, or am I okay with what you just offered me? If the answer to that is not just yes, I mean essentially, then you need to renegotiate. When the reaction is, yes, but I'd like a lower hourly rate, or yes, but can you guarantee me a higher resource bandwidth, sort of, yeah, but I'll need at least 80 hours a week. Then always imagine in your heads that there is a question mark. Is that okay with you? If it is, then I always recommend that you record everything. Give me a second. When you need to renegotiate, please always record everything there is to it. You might sometimes have a switch of communication channels. You might send out an actual quote as a PDF, and you might get a yes but via email back. Whenever there is anything changed, record, keep everything that there is in that correspondence, just so that you can make absolutely sure that you have an agreement on something specific. One of the things that people are sometimes hesitant to do, but there is no reason to do it, is to straightening out the correspondence. If you feel that gets sort of wishy-washy and you don't really know anymore what you're agreeing on or what the client really wants, then ask them. Write them an email saying, am I getting this right, that you're saying the hourly rate is okay, you want us to start at the beginning of March, but you need 80 hours a week or something. Ask them and wait for the yes. Don't just do what some people do and just start working. Unless you just say, it's a marketing thing, it's a big client, I need to be working for them anyway, and if they don't pay me the way I want to, it'll still be okay. I don't recommend doing it, but some people just start working, assuming or trusting. Sometimes people trust their clients, which is very important. I do that too. But then you really have to follow your gut. If you have a good feeling that something is going to work out anyway because you've known the people for a long time or because of some specific reason, you will be doing it anyway. But just make sure that you have a good reason to do it, and don't be disappointed if the shit goes down the drain, because I mean, obviously, some people approach me with fights with their clients. They don't pay fast enough. I see some arguments about stuff like that, so I always recommend to be careful about it. Sometimes, and just to be clear on this, sometimes having no written agreement is better than having just anything on paper. Obviously, much of my work evolves around wording contracts, which I think is a thorough written contract is great for both parties because you know what you live by, what you adhere to. You know exactly when the pay is due, you know exactly what to deliver, when to deliver, stuff like that. But in many cases, people, especially startups or especially freelancers, just go, I'll start anyway. It's okay. We don't need a contract. We have an oral agreement, which is fine. You don't need a written agreement in many cases. There are very specific contracts that you need a written, sometimes a notary contract for something, but that would be rather when you buy real estate or something. For software development contracts, you don't need a written agreement. Sometimes having no agreement at all is better than having a faulty piece of paper that they will come back to and say, hey, but this is what we agreed upon, and you know that they didn't. So try to have a thorough written agreement, but if you don't, or you just think, ugh, it's not that big of a deal anyway, I'll just do it without, then that's better, because then the client has no piece of paper to come back to and say, hey, this is what you signed. Because then it'll be something of trust for both parties. What I always recommend, even if you have no written agreement, what I always recommend is that you make a list of the essential parts of the contract. Anything that you will always need to know about the contract, just in case you have amnesia and you wake up the next morning and you go, ooh, I'm never having tequila again. You need, this list better be good enough that you can look at it and go, okay, that is the client. Sometimes when you have big corporations, it's also quite important to know what company in that corporation scheme you're working for. What exactly you do. Is it that you have to deliver them a specific piece of software? What is it? Do you just consult? Do you support? Do you do stuff? That's what I always recommend. Always hands up if you have a question. I have a pretty bright light, so I'm not sure I see all of it. Marie, do we have a microphone for questions? Okay, Basti, perfect, thank you. Okay, second thing. Thoughts on the fine print, the boring stuff. Fine print, usually general terms and conditions, why you should read it and what to do if you don't like what you read. First of all, you might be big enough, or you might have your own general terms and conditions, and you just might not know it yet. GTC are something that you set as a basis for everything that you do. For example, it would be payment periods. When you issue an invoice, and many people don't know that if you don't write anything specific on it, that means it's due immediately. I have a client in Switzerland, and I started working for them in January. And I didn't agree to any of their GTC just because lawyers are usually not asked to, for some reason. Then I sent them the invoice, and then 3 weeks later I get a call from the booking department, and they say, oh, we thought it's due in 30 days. And I say, that's interesting, why? And they say they don't know that I never agree on anything, and they said, well, if you want it to be due immediately, why don't you write it on your invoice? So with them I do, but anyway. If there's nothing agreed on it, it's due immediately. Usually what you do is you invoice already rendered services anyway. So there's no legal period, but 30 days is something that many international companies base their entire booking on. So in many cases don't expect payment any sooner. But what they often do is they reject yours because they say we accept your offer under the condition that your GTC are waived and ours are applicable and everything. Especially if it is a large corporation or a larger sale that you're making. If you sell a lot of services, I would always even briefly read their GTC, because sometimes you might see they're not applicable at all to what you do because they're so basic or they concern a different department, doesn't matter. But if you read through stuff, and I would always look out for this. That is something that can always hurt. A contractual penalty, I'll come back to that in another legal thing that I want to talk to you about today. When you see contractual penalty, that is always something to look out for. In NDAs too, usually, and here's a secret, that's not so secret, but nobody really ever asked me what I do. Sometimes people approach me and say, hey, can you examine this NDA, like a non-disclosure agreement? Can we sign it? I mean, it's not exactly the only thing I do, but the main thing I do is I scan it for contractual penalty, because that's what really hurts. If you agree that you may never disclose information, and sometimes like everything is disclosed, like confidential information, you may not do anything, but there's no contractual penalty. That means, well, don't make a breach of this contract. But if you do, it has no consequences. So that is something I always to look out for. A contractual penalty, when it says that, watch out. Now, and it's always difficult if you have colliding GTC when sort of both of them apply. It's always an interpretation thing. What do you do if one set regulates something that the other doesn't? What if you have an actual collision of, let's say, payment periods? Usually what happens is, the rule of thumb is the GTC of the provider apply. But it really depends on the case. Sometimes you have a really big client and a really small supplier. Don't bet on it as a small supplier. But I have heard of cases in which, let's say, substantial business with a large German telecom provider did not actually make it to be because the CEO of the company, the providing company, said, well, if your GTC are supposed to apply, we're not doing any business with each other. Now, and here's something that's Germany specific, but it's the case also in many European countries. What we have is a law that GTC, meaning something that you word for not only a specific contract, but for various uses, AGB in German. And it really doesn't matter if it says GTC at the very top or if it's something that you word in any and send out in any quote that you send out. The same law applies to that as well. If you have something that's unreasonably disadvantageous, unzumutbar benachteiligend, unangemessen benachteiligend in German, then it is very well possible that this very rule doesn't even apply. It is as if it wasn't there. You can sign it, you can sign the contract knowing that it won't be valid, and it's as if it isn't there. So if the other party doesn't want to adhere to it, they just don't have to. But that rule does not apply in all the countries. For example, Ireland has a very loose law on this, and that actually doesn't really exist, which is why many corporations have their residences in Ireland, for tax purposes obviously too, but for that reason too. However, now I said I would give you an idea what to do if you don't like GTC, meaning you could sometimes even accept them if you know they're not valid, but it's kind of difficult to know. But what you can always do is you can individually negotiate a certain clause. If some of your clauses you absolutely definitely want in the contract, you can renegotiate them. Even if they're in your GTC, if they're individually negotiated, they're always valid. If you start negotiating and you come to an agreement, that is always binding. Thing 3, that's not my job. Or is it? That deals with something that I said in the beginning too. Now, sometimes usually, essentially, it's about getting paid, but also about making good, delivering good work. But what do you really have to do to get your money? What's in your job description? I told you that I would always keep a list of essentials in the contract. Among this list, or in this list, I would always include, this is very, very much related to the German discussion of Dienstvertrag, Werkvertrag. What do you have to deliver in order to get your money? Do you render a service, or do you actually basically sell a ready-made piece of software? This is very, very important for software developers, because sometimes, and that really, there's everything from both ends of the scale. Sometimes it is, then it's always important to look out for words in this contract, or how it doesn't matter if it's written or oral. How do you market? What did you sell, or what are you selling? Are you selling software development, which could be anything? It could be you're sitting there. You could be like a borrowed human resource sitting there for, let's say, 3 months straight, 40 hours a week. And you could have a project leader telling you what they want you to do, and you're just paid by the hour. Then that means you would rather support the team than taking the project lead. That's an entirely different scenario than someone approaches you and says, I have no idea what I need, but I can tell you this is what I'd like this is what I'd like to work. Can you create something that will do the job? In that case, you're obviously, and initially it might be some consulting, which might be paid by the hour, and it's not an either-or thing. Sometimes, in many cases, it's contracts that are mixed with a consulting part, a training part maybe. It could be a support part of some sort, but then it might also be that you create a specific individual piece of software for this client that only they want to use, and that might only make sense in that very environment. So that very piece of software might need a sheet of specifications. I'll come to that in a second too. In which case you have a mixed contract. One aspect of your services is paid by the hour, and the other you might only be paid for once it's delivered and accepted. So that is something to look out for too. This is really important. Questions to determine what kind of mix you have, or if you have a mix at all, or what kind of service or of software you get paid for is, who determines your concrete coding tasks? Are you part of a division? Are you like one of 10 coders, and you get together in a scrum meeting every morning, and then tasks are distributed, and you're one part of a team of coders that come up with something, and you really cannot tell anymore whose part was what and stuff like that? Then it would rather be a service than an actual piece of software, meaning it doesn't really have to be accepted. You get paid by the hour, full stop. And obviously the approval, the acceptance process, does it require that? Can you tell? And obviously you would be so close to your work that you are the best ones to tell whether it actually does need an acceptance or approval process. Sometimes I have no idea. When as a lawyer I'm approached and I really don't know who accepts what, and it's just keep your eyes open. If you ever want a lawyer to help you with something like that, just keep in your head that they might not know the actual working process, whom you give your work results to, and if anyone else works with them, or if you actually create something very specific that you hand to someone specific who specifically has to accept what you did. So it's very important to figure out what your job is. Speaking of acceptance, sometimes it all goes well until you need acceptance, approval of your work. And in which case, sometimes it all works well until you need someone to say, yes, what you did is fine, here's your payment. What do you do then? First of all, and one of the things that many projects get kind of wishy-washy on one part is that it's always difficult if you don't watch out from the beginning on is what exactly do you have to deliver? When does it have to be delivered? And by what criteria will it be measured? And that is really well, it is rocket science because we're at revision 2015, but it's not all that difficult to determine what you need to do, when it has to be delivered, and who will have to measure what. Just make sure you stay out of this, yeah, you'll get paid once we're okay. Just be specific. Think about what will have to happen so that you get your money. Just pose specific questions like, so once I'm done, who will have a look at it and what criteria will it have to meet? So, oh, okay, I'll come to that in a minute. Make that, if need be, make that part of your sheet or sheet of specifications. Specify way in advance what you need to deliver, when it has to be delivered, whom you will deliver it to, sometimes even means of communication. How do you hand it over? Is this, is it an SVN that you upload it to? Does the person that has to accept it have it? Does it have usage right? Does it have access? And what criteria? What criteria does it have to meet? Because what usually happens if this is not prepared well is you will deliver a piece of software, and first of all, the client usually doesn't want to pay you for it. And it's not that the company is actually intrinsically bad. It's just that the person that has to accept it has a liability problem internally too. Because once this person says, yes, this software is fine, and especially if the person has no idea about software and software errors and mistakes and what to do, then this person will have to justify its decision to say, yes, the work that we got was okay. Because, I mean, software is never 100% error-free. And so what sometimes companies want to do is they try everything to stay out of the approval, just so that they might delay your payment. But that might not even be their biggest problem. The biggest problem might be that once they say yes, you can always relate to that and say, but you accepted the software. It was okay at the time. So just make sure that it's measurable what criteria it has to meet, because then you can always come back to that and say, look, sometimes you do approval processes together, and you say, these criteria were met. If you want anything altered, I can do that, but it'll cost you new money. What I sometimes do, or no, what I usually recommend to do is to include in a written contract a fiction of acceptance. That means basically a clause that will say, I'll give this to you, and if you don't do anything for a specific time, I will deem the work that I deliver to you is deemed accepted. That is possible, and it is done often, and it makes perfect sense, because that way you can make sure that the client will actually do something upon delivery of your software. This is just an example. I'm always hesitant to give you examples of concrete wording, because what people do, especially with samples, is they sort of magically assume that this will be the right wording in every case. But just to give you an example, when you have capital letters like here in client, that means it's usually related to a predefined term client, which will be at the very top of the contract. So an example would be the work delivered to client is deemed accepted unless client notifies developer, which would be you, of any defect in text form. Here you can also see that I'm creating, that I'm defining how exactly they have to inform you. So text form would not only have to be, wouldn't be only paper, it could be email, but you know, and in a way that allows developer to locate and reproduce the defect within 2 weeks after delivery. That is the notifies within. So what you do in this one, you set a period of 2 weeks, and if they don't notify, it could be 4, it doesn't have to be 2. Just make it reasonably long so that they actually have a chance to examine what you did. And this is really interesting, and this is really important too. So I wouldn't only say, let me know within 2 weeks if there's anything wrong, because that way they could always say, oh, there's something wrong, and you go, okay, but what? And especially if the client has no clue of what you did. Yeah, it's fine, it's wrong, that would be not fine. Okay, so reproduce the error. I'm halfway through, I'm kind of lagging. Okay, speaking of which, can you? So I'll speed it up a little bit, but I had to clear up some basics so that you would know sort of what to expect. Speaking of which, can you? That is especially dangerous in business meetings. Business meetings in general are a problem in many cases, but one of the things that you have to look out for is the speaking of which, can you final sentence in a meeting. Because that way, sometimes you get in a meeting and they say, oh, now that and then for the first time they notice, oh, we actually need something else too. And when they tell you, oh, could you do that too, just make sure that you know, anytime that you agree to any change, you might actually change the specifications. And what's worse is you might not have any record, because it'll be oral in a meeting, go, oh, can you, by the way, can that converter also do, and you go, yeah. They didn't actually say, then please do it and we'll pay extra for it. You just agreed to do it. What does that mean? You also might have to do something you wouldn't have agreed to in the first place. If, assuming the client had come to you beforehand and said something like, could that converter also do a certain specific task, you would have said, no, it really can't. But sometimes in a meeting, when it's in a side sentence, you go, yeah. Or you didn't say anything, but the client rushes out because there's a next meeting that they have to go to. And you go, no. But they expect you to do something. That's always a problem. Stay away from that. Whenever you sense that the client wants something else, pin it down. Like, if need be, send them an email saying, I understood that you wanted me to do Just be aware that it'll be extra costs, it'll change a sheet of specifications, stuff like that. And of course, unpaid extra effort, always something to stay away from, and at worst even unpaid. Sometimes they want impossible stuff from you, so try to avoid that. Record everything that they want changed. And if you're clever, then agree in your contract, in your initial contract, that change requests are paid extra effort. When they change their mind, make them pay for it. Very close to that, agile software creation. That's something that IT lawyers struggle with, probably more so than the actual technical staff. Agile is great in cases you don't know what exactly you need done in the first place. But it is not great if you have a client that really is clueless and it's just they're just lazy and they couldn't care any less and they just want you to do something. Those are the worst clients because they have no clue. When you have a client like that, just do one step back and say, we need to specify exactly what you need. You will know. You probably know much better than I do when agile software creation is a good idea and when it isn't. When it is, there's always, of course, a way to handle it, but then always make sure that you define anything that you can as soon as you can. If there are variables, address them specifically and say, what does it depend on to determine this and this and that? If you cannot say specifically, just lay out the actual structure for what the project will look like. Specify why something cannot be defined yet. just so that you can always relate to that and say, well, no. At the beginning of the project, we said we would specify at that milestone what way we would be going in that branch, and also state what will be done once it can be defined. So you have an actual schedule to work with. And yeah, just don't confuse the "we will define later" with "we'll see about that." And if you can, that's always something that I always stress. Try to stay away from open source software unless you really don't care about, and your client also doesn't, about rights of use. If you create individual software, your client will probably expect exclusive usage rights, and you will not be able to give them that when you include something that someone else has given a different license out for, because that is contagious. Bring your own code. Try to avoid, I already addressed the open source problem just now, but try to avoid that because, oh, I already did say that. Exclusive rights are always a problem also, if the client expects them, if you want to further develop and market your software. Very often I have cases in which a developer approaches me and says, hey, the client has been paying me by the hour for, I don't know, a year, and the platform has now come to be. And I'd like to market that piece of software. They didn't create everything. They just created a certain piece of software that can be very useful for different internet platforms, possibly. And they didn't really have a written agreement. And they asked me, am I allowed to approach other clients with that? Because it's very good. It's a very good algorithm, and I'd like to market it. And I go, probably not. If you are exclusively paid by a client to create for you this very piece of software, then chances are they will, rightfully so, expect exclusive rights of use. If you know exactly that you're creating something that you want to further develop and market, say so in the beginning. Say, I will create this for you, but I will also want to market this piece of software somewhere else. If they say, oh, no, exclusivity, it might very well be that you might be able to renegotiate that you can market it in a different branch, in a different industry. And they just say, oh, no, you may not market that in, like, let's say, car manufacturing. And you weren't looking at that anyway. You were looking for, I don't know, online dating platforms or something. And that is actually, what is going on with that? I've been approached by various developers related to the demo scene that create, let's say, online dating services. Yeah, no. Did you create Grindr? No, and it's a heterosexual platform in both cases, I think. Unless they really don't care, you can never tell today. So think about what rights of use you want to grant and want to reserve. And open source always pollutes, it's contagious, pollutes your software because very often you have to grant the same rights as you were given by the open source software developer in the first place. If you need to use open source software, keep it as separate as possible, making a separate library or something. Just keep it out as much as possible. Covenant not to compete. I already addressed the thing briefly just now. How to stay exclusive or not stay exclusive. Some clients, and that is not only the marketing your software problem, but some clients will want you to stay away from business with everyone, basically. That you belong to them only because what you do is so great that they want exclusive ownership. Now, since slavery has been never as cheap as it is today, the thought is appealing. I see that, but what they want is what you sometimes see is this: they prohibit business with anyone in direct or indirect competition with the client. Sometimes even with the contractual penalty, something that I told you to look out for. Now, That obviously is a problem on its own, but sometimes you might very well be okay with staying away from business with someone. But what is business? Does it mean you sell them something? Is it something that does it mean that they sell you something? Is nonprofit work included? And what is indirect business anyway? I mean, when you exchange invoices, obviously that's business. But what's with seeing them at a trade fair and talking? And what if the company approaches you? And also, what areas does your client compete in? And also, I mean, and I should have included this in here. How do you know what companies your client approaches or does business with? Sometimes you don't know. So what I always recommend is if they actually insist on this, make a concrete list of persons you won't work for. Just concrete persons. Make a list. Say, okay, I get your problem. Give me a list of companies that I may never work for as long as we cooperate. Sometimes they're hesitant to give you that list because obviously it might even be confidential information. So sometimes that's a nice way to get around it. But addressing this specifically is good.
Can I write a time limit for that?
Yes, you can.
Okay.
Time limit, always possible. And how to end a relationship with style. Sometimes, I mean, obviously, any relationship can come to an end at some point. Make sure that you know this. When the contract has an indefinite term, it is theoretically terminable by notice. It will be said in the contract. But if a contract has a specific duration, a specific term, then usually you cannot terminate it in between. It's like a lease. If you have a 2-year fixed lease, and for a certain office or flat, then they can't just say, oh no, get out, 3 months. They can't. If you have an indefinite term, you obviously have to be able to terminate it somehow. So there might be a period specified in the contract, but there's always extraordinary termination possible, but only for very, very bad reasons or very important reasons. If you absolutely positively need to end the business relationship, something that shatters the business relationship so fundamentally that you cannot continue working for them. Don't count on that ever to be. Try to be as gentle as possible. An extraordinary termination is a pretty big thing to do. Something to look out for too. Sometimes when you work for big companies or big corporations, what you have is a frame agreement laying down all the GTC, all the terms that you adhere to. That also says we can individually hire you or ask you to do specific tasks, individual contracts. Sometimes that will just be a one-sheeter saying we want that piece of software, we want 40 hours from you that month. Sometimes the termination of a frame agreement, or usually, it might not touch the individual contracts. So just because a frame agreement is terminated doesn't mean that the still running agreements, the still individual agreements, have to be terminated. In case you need to fight, which is never a good idea, and in IT, almost nothing ever happens to go to a judge, because especially, I don't know how that is in other nations, but in Germany, many people don't sue because you just don't want a judge that has no clue of what you do decide on your financial fate. So just in case, try to read the fine print also to figure out if you agreed to a different national law, like what law is even applicable, is it Irish, is it whatever. And usually, or what sometimes happens is there a venue, like a legal venue defined? If you need to sue, or if a lawsuit comes up, where will it be handled? Will it be at your residence, at the client's residence, at an arbitration somewhere else? try to read that. If not, if there's nothing defined, usually the basic rule is that the lawsuit is handled at the residence of the defendant. Just so that you know. All right. I have taken much longer than I thought, but I will still be here for questions. 10? 10? Jürgen, what is 10?
Minutes.
10 minutes?
Before 11.
Yes. My laptop says the time too. It's funny.
Why might you want to terminate a contract?
Yes. Terminate it. What? Or was that a question, actually?
Certainly was, sir.
Sorry?
Why might you want to terminate a contract?
The client might. You might. Just
Why?
because you want you don't want to work for them anymore. Just go, I don't agree to your business ethics anymore. Don't want to work for you anymore. It might be that you have a better offer from someone else, paying you much more money. Or you might want to do that in order to get a new contract with them. Which, of course, I mean, by agreement, you can always do that. You can always say, let's agree on terminating this altogether right here, right now, and we will have a new contract with a different hourly rate, different task, whatever.
So, in the absence of extenuating circumstances, a way to sort of...
Sorry?
In the absence of extenuating circumstances, a way to unwind the contract, regardless of the company having created a glitch or having caused a problem against you. This is like for a polite wind down. There's no cause, no reason. It's just a personal. I want to get it.
Yeah. Yeah. You can do that without any personal reason. That doesn't have to be a specific reason. You might not give a reason, really. I mean, especially when you have had a long business relationship, they will ask why. But you don't have to give a reason. It is not, especially not in Germany, it is not necessary to give a reason. Everything else, contact data, you know. Okay, I have come to the end of the official part. If you need to change clothes, you're more than welcome to do that anywhere you want. You might have seen the stickers that I put out at the banner with the, that. I am now officially releasing the stickers without any text, and I also release white markers if you want to create your own text. And I'm not quite sure if the markers out there are still good. I'll renew the markers out there so that you can use them as well. And yeah, please tell me if that actually works. I've tried it with various phones, but you never know. All right, thank you very much. I'll be here for questions. I won't be participating in the 5K run. As you might have heard, my voice is a little off. And for the first time in over a year, I have actually had a cold. I've hit Easter. It's perfect. So I won't be participating in the run myself. But by all means, please do stay fit, stay out of problems. If you happen to have a problem, I'll be here for the entire party. Approach me for a beer, for a legal question, for whatever you want. Thank you.